Committee will come to order. Good morning, everyone. Welcome to our last committee, probably, of this 118th Congress. And throughout this Congress, the committee has devoted a lot of time to enacting legislation holding the administration accountable to improve Biden-Harris administration's management of VA. And it is the fundamental duty of this committee to make sure that no matter who is in the White House, the administration that's in charge is properly carrying out the laws to serve veterans in the way that Congress intended. For too long, there's been a disconnect between Congress's intent when making laws and how agencies put laws into practice through regulation and guidance. This has been especially true under this administration, but earlier this year, the Supreme Court ruled that the status quo wasn't cutting it. There is a lot of work that happens behind the scenes to make sure the laws Congress send to the President's desk are well developed. Therefore, there's no excuse for VA blatantly ignoring Congress's will. One example of VA ignoring the will of Congress was VA's decision to transform the character of the VA home loan program through VASP. Especially, the Biden administration changed its interpretation of the law that allows the Secretary to, on a limited basis, to take over mortgages at a low interest rate for a veteran or survivor in need. VA's new interpretation of the status allows VA to take over mortgages for around 60,000 veterans facing foreclosure at an interest rate of 2.5%, well below the current market rate. VA's decision to become a lender for tens of thousands of veterans who are high-risk borrowers at an expense of the taxpayer directly undercuts the intent of Congress in the law that we passed. Remember, members on both sides of the aisle on this committee pushed back on the administration for this move. Despite this, our letters and concerns were ignored. VA did not concern itself with the intent of Congress when the statute was enacted, only with how far they could take the authority now. This is one example of what a few of us, as we saw as overreach by the VA, that directly impacted veterans and taxpayers, all the while undercutting the intent of the law. VA's pattern of interpreting laws not how Congress intended, but in ways more favorable to VA, is unacceptable. The Supreme Court's recent decision in the Loper case will hopefully restore some of the balance to our system of checks and balances. The Loper decision provides an opportunity for Congress to assert its rightful position as the creator of law. To make sure this happens, Congress needs to provide less direction to agencies in the law. Instead, Congress should give agencies concrete direction about its intent. I look forward to the hearing from our witnesses today on how Congress can work to ensure its legislative intent is being effectively communicated and implemented. And with that, I would like to now recognize Ranking Member Takano for his opening statement.
Thank you, Mr. Chairman. In its decision in Loper Bright Enterprises versus Raimondo, the Supreme Court overturned 40 years of precedent and radically transferred power from the legislative and executive branches to the unelected judiciary. And contrary to what my colleagues believe, going forward, it will now be much harder for Congress to exercise its power, and our policymaking judgment will be substituted with that of activist judges and their clerks. I have long heard arguments from my colleagues across the aisle that from my colleagues across the aisle that Congress's authority somehow diminished since Chevron versus National Resources Defense Council ruling in 1984. However, Congress has always had the power to be prescriptive and deliberate with its legislative drafting to make its intent clear and unimpeachable. We also have the choice to be vague, intentionally vague, or to give an agency flexibility in interpreting our legislation. And with that, until Loper, we accepted that the agency would use its superior technical expertise to implement those laws. Now, we may quibble with that expertise, but nevertheless, that is the schema. Now, my majority colleagues, in their anti-intellectual fervor and rush to condemn, quote-unquote, unelected bureaucrats, are celebrating the fact that well-trained and educated experts will lose the discretion that we purposefully, intentionally bestowed upon them in hopes that unelected federal judges will rescue them from their inability to legislatively enact their corporate welfare state. The Supreme Court did not wave a magic wand in its Loper decision and endow some new superpowers in our hands as members of Congress. In fact, Loper does not make any actual changes to how Congress must draft or how agencies must interpret legislation. Congress will continue to decide how much discretionary authority to delegate agency heads, and Congress will still be as specific or as vague as it chooses to be in how it tells an agency to act. No doubt, my colleagues across the aisle are going to be bullied on countless occasions to be deferential to the incoming administration. Now, Congress has often delegated broad discretion to the VA Secretary. The Loper decision will not result in a seismic shift in how this committee does its job or how VA implements the laws we pass. And I disagree with the majority's assertion that Loper gives Congress some new tactics to seize authority back from VA or to assert our rights as the legislative branch. Again, we've always had that power to direct agencies to act and prescribe specifics as to how we want them to act. It's up to Congress to authorize, and it's up to Congress to appropriate. That does not change under Loper. What does change is how the courts will review administrative actions taken by an agency. Judges will decide the best reading of an ambiguous legislative text, and if an agency fails to apply that judge's best reading in its rulemaking, the judge will likely invalidate the rule. This is a massive shift of power from agency experts to subjective, unelected judges who may or may not have any sort of knowledge base on the topic at hand. Sweeping policy implications will rest solely on which judge hears the case. Corporate interests that can afford high-powered, well-connected attorneys will challenge agency actions that don't boost their self-interest and will likely win under this new Loper scheme that promotes the cronyism the Federalist Society exists to preserve. Claim sharks, private equity-owned healthcare, for-profit colleges, and pharmaceutical companies will march their attorneys into our federal courts and challenge any federal VA rule that does not bolster their bottom line. Our legislative efforts to modernize VA will be thwarted by profit-driven IT companies with multi-billion-dollar taxpayer-funded contracts who routinely fail to deliver functional IT solutions. And veterans will be the ones who will be left worse off. Loper not only shifts interpretive authority away from agency experts, it takes away the power of Congress to choose when it wants to implicitly give agencies discretion to implement law. Judges will now be positioned to strike down agency rules that are within the broad discretion Congress intended because the agency did not apply what in that judge's mind is the best reading. Essentially, the bought and paid for conservative majority Supreme Court said that even when Congress thinks it is delegating interpretive freedom to the agencies do not get to exercise it. Instead of that power flowing back to Congress, however, it flows into the pens of unelected judges and their clerks. Now, sometimes we are ambiguous and flexible on purpose, especially on this committee. Flexibility increases the chance that VA can learn or can lean on current laws to address problems veterans may face in the future. And one of the best examples of this intentional flexibility was in my Honoring Our Pact Act. As VA finds out more about the harmful effects of toxic exposure through research over the years to come, they will be able to issue regulations to add presumptive illnesses for which veterans can qualify for health care and benefits. This will save thousands, if not millions, of lives because it can often take decades for Congress to act on these presumptive illnesses. Moreover, my colleagues fail to appreciate that to be prescriptive in legislative text in the way the Supreme Court suggests will be necessary for Congress's intent to be obeyed, we will need an infusion of resources, capacity, and expertise on our committees and across the institution. We failed to pass a legislative branch appropriation bill this year because my majority colleagues refused to prioritize resources for this body and our ability to serve our constituents. I would say it's pretty clear that many, many experts believe in response to this Supreme Court decision, Congress will need to beef up its capacity. My Republican colleagues defeated the appropriations bill that funds offices that will make our legislative drafting better, like the Office of Legislative Counsel, the Parliamentarian, and the Congressional Research Service, because they believed they were providing too much to the offices that are the bones of this Article I institution. We also need to invest more time and effort into the legislative process. Very little oversight was done on numerous Republican legislative priorities, and they were attempting to force policies based on anecdotal information. This is a poor way to make policy, and it only sets us up for failure. If we want agencies to implement laws, well, we have to spend the time perfecting legislation, and we can't legislate on feelings alone. So, if my colleagues on the other side of the aisle are serious about reclaiming some of the perceived lost power to make congressional intent clear in this post-Loper world, we need to be intellectually honest with ourselves about the investments we will need to make in our committee staffs and the staffs of the already overly burdened legislative branch offices that support us. So thank you, and I yield back.
Thank you, Ranking Member Takano. We will now turn to our witness's testimony. And so before us today is, I'm going to try my best, Chad Squitieri, Assistant Professor of Law at the Catholic University of America, Columbus School of Law. Dr. Philip Walrick, Senior Fellow of Social Culture and Constitutional Studies at the American Enterprise Institute. Mr. Jonathan Gaffney, a supervisory attorney with the Congressional Research Services, and Mr. John Vecchione, Senior Litigation Attorney with the New Civil Liberties Alliance. Will all the witnesses please stand and raise your right hand? Do you solemnly swear that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? Thank you, and let the record reflect that the witnesses answered in the affirmative. Mr. Squitieri, you are now recognized for 5 minutes to provide your testimony.
Chairman Bost.
You as Congress are complicit in the genocide in Gaza. You keep sending billions of dollars to Israel. Meanwhile, veterans are homeless and committing suicide with more.
The witnesses will hold on. Say it again loud. The audience will refrain from public. You will be removed from the building. You will be removed from the building.
We will suspend until Capitol Police can clear the room.
The room will be cleared of any protesters.
Give you the moral courage to do the right thing. May God give you your heart, please.
Have her removed from the building. Merry Christmas.
Stop sending bombs to Israel.
Is she moving? Okay. Welcome to Congress. You may resume your testimony. Thank you.
Chairman Bost, Ranking Member Takano, and distinguished members of the committee. Thank you for having me here today to discuss how Congress and the Department of Veterans Affairs can serve veterans after Loper Bright. My name is Chad Squateri. I'm a law professor at the Catholic University of America, where I focus on administrative and constitutional law. In connection with my work as a law professor, I also serve as a managing director of the Center for the Constitution and the Catholic Intellectual Tradition, and as a fellow and director for a project within the Separation of Powers Institute. The Supreme Court's decision in Loper Bright brought about a welcome change to federal administrative law, and the decision should be celebrated for at least two reasons. First, because of the decision's impact on federal courts, and second, because of the decision's potential impact on Congress. As to the courts, Loper Bright frees judges to give legal effect to a statute's best reading. Prior to Loper Bright, courts were often required to adopt a less than best reading of a statute, simply because that less than best reading was offered by an administrative agency. This required courts to place a thumb on the scale in favor of one class of litigants, federal agencies, and thus disfavor other types of litigants, such as veterans, who might argue that a federal agency acted unlawfully. Federal judges, however, should not give undue preference to any litigant that comes before them, including federal agencies. There is more that could be said of Loper Bright's impact on federal courts, but today I'd like to focus on the second reason why Loper Bright should be celebrated, the decision's potential impact on Congress. Past Congresses have delegated far too much power to unelected bureaucrats. The reason past Congresses had for doing so were no doubt varied, but I suspect many legislators came to the conclusion that it was often politically costly to take clear and bold stances in federal statutes. What's more, a legislator might have concluded that it was politically safer to draft broadly worded statutes and hope that, depending on who wins an election, politically friendly agencies will interpret those statutes in a way the legislator preferred. The Loper Bright decision gives Congress an opportunity to recognize that the political calculus has changed. No longer should legislators simply hope that a broadly worded statute will be routinely interpreted by a politically friendly agency. That is because, after Loper Bright, statutes should be interpreted by politically independent judges. This should give Congress an incentive to retake the reins from federal agencies and to begin to take bolder, clear stances in federal legislation. Thankfully, this committee, under the leadership of the chairman and the ranking member, has already demonstrated through this hearing the sort of legislative initiative that one hopes Loper Bright would inspire. The question then is, how can congressional power be restored in the wake of Loper Bright? And I will conclude by respectfully offering three suggestions. First, Congress should see Loper Bright as an opportunity rather than an obstacle. There has been some talk of Congress seeking to override Loper Bright by enacting legislation that would purport to require courts to again defer to agencies in a way similar to the old Chevron regime, but that sort of legislation should be approached with caution. In Loper Bright, at least two justices signaled that Chevron deference presented constitutional problems of the sort that would have to be overcome by constitutional amendment rather than ordinary legislation. Second, Congress should consider how courts, working within the Loper Bright framework, might assess legislation. The Loper Bright framework recognizes that statutes may still empower agencies to exercise flexibility. For example, statutory terms such as appropriate or reasonable can afford an agency broad policy discretion. Sometimes legislators may wish to grant such discretion, but legislators should only grant that discretion intentionally and with due circumspection. Moreover, legislators should consider how they can narrow grants of discretion by requiring agencies to exercise discretion in certain ways. For example, this committee might not know now how it wants the VA to exercise policy discretion in unknown future context, but the committee might know that certain considerations, such as a desire to specially consider regulatory impacts on Gold Star spouses, should be relevant regardless of what the future holds. Simply requiring the VA to consider evergreen factors can help narrow the discretion afforded to the VA while still leaving the VA flexibility to adapt to future context. Finally, Congress should recognize the limits of Loper Bright and use the case as inspiration to go even further. Of particular note is a distinctive form of deference called Kaiser deference. Kaiser deference, which concerns agency interpretations of their own regulations, was arguably undisturbed by Loper Bright, but the Kaiser case actually involved the VA, and members of this committee might find that it is often the VA's interpretations of the VA's own regulations, rather than the VA's interpretations of statutes, that are most objectionable. This committee could rectify that situation by closely scrutinizing the VA's interpretations of its own regulations and considering legislative overrides where appropriate. More boldly, this committee could consider legislation that would prohibit courts from offering Kaiser deference to the VA. In conclusion, thank you for your invitation to allow me to address how Congress might serve veterans who have already served us all.
Thank you. And though you're not lined up this way, Mr. Wallach, we've got you down to go next, if you would, for 5 minutes.
Chairman Bost, Ranking Member Takano, and members of the committee, thank you for the opportunity to speak with you today. Unlike my fellow panelists, I'm not a lawyer. I'm a political scientist who studies the institutional realities of American government rather than the nuances of legal doctrine. A recurring theme in my research is that moving decision-making authority away from politically accounted elected officials and into the hands of unelected bureaucrats leads to policies that are substantively flawed and legally unstable. In my studies of Congress, which is often a dysfunctional institution, the Veterans Affairs Committee has consistently stood out as a bright spot, known for solving the problems facing America's veterans. So I'm hopeful that your committee can demonstrate how bipartisan legislating can improve both policy outcomes and legitimacy. Throughout the halls of Congress right now, members are asking themselves what to make of recent doctrinal developments at the Supreme Court, including Loper Bright, but also in many other cases in recent years where the court has signaled a less deferential stance. The justices have clearly announced that they do not want the executive branch acting as an independent legislative authority, with agency lawyers stretching existing statutes beyond recognition to justify new programs. They want Congress to be the branch to answer the major questions. That doesn't mean they desire to see an end to congressional delegation, but they want delegations to be clearly bounded. This doctrinal shift is promising, but it alone will determine very little about how policymaking will evolve in the years to come. If legislators sit back and watch struggles between agencies and litigants play out, congressional marginalization may continue apace. What we need to avoid that fate is for legislators to rise to the occasion and legislate, rather than just cheerleading for executive branch actors. The remedy for excessive administrative power needs to be revitalization of congressional power, not just a different flavor of administrative power. What should that revitalization look like? It must centrally involve more lawmaking generated by nimbler congressional committees. Executive overreach must be countered by quickly formulating legislation, moving it onto the floor, and getting a vote. Oversight and informal communications can be first responses, but they cannot be last steps if an agency persists in an interpretation that diverges from Congress's intent. Oversight disconnected from lawmaking becomes mere commentary. If our current legislative processes make such rapid legislative responses too cumbersome, then we need to reform those processes. Now, I don't claim to be any expert on veterans issues, but I'd like to briefly apply these general observations to a specific issue under your jurisdiction, the Veterans Affairs Servicing Purchase Program, VASP, which Chairman Bost opened the hearing discussing. So I won't repeat what he said about the structure of this program. I think, by all accounts, the VA was responding to a real problem, service members who faced unaffordable back payments after COVID-related mortgage relief expired. But their response strikes me as a textbook example of the hazards of executive policymaking. In order to conform to what existing discretionary powers they had, they fashioned an extraordinarily generous form of relief in this 2.5% interest loans. I feel many veterans who currently bear the burden of mortgages with 7 or 8% interest rates may find that irresistible, and the program's protections against strategic default seem rather feeble. On the other hand, veterans who already agreed to harsh loan modifications will get no relief. Maybe this program can succeed on its own terms, even if a cloud of legal uncertainty is likely to hang over it. But it strikes me that the VA's insistence on using its existing powers rather than working with Congress to fashion better targeted relief led it to adopt a rather crude solution. Had Congress asserted itself, the resulting policy might well have helped more veterans while costing taxpayers less. Easier said than done, I know. And yet I believe it may have been possible for Congress to decide on the solution to this problem and legislate accordingly. If that prescription seems to rely on a pie-in-the-sky idea of how the House operates, then once again, we need to be asking how to make this institution work better for the American people. I'll stop there and look forward to the committee's questions.
Thank you. Mr. Gaffney, you're now recognized for 5 minutes.
Chairman Bost, Ranking Member Takano, and members of the committee, good morning. My name is Jonathan Gaffney. I'm a supervisory attorney with the Congressional Research Service in the American Law Division. Thank you for the opportunity to testify at today's hearing on the potential impacts of the Supreme Court's decision in Loper Bright Enterprises v. Raimondo on the Department of Veterans Affairs and Congress's oversight of VA. Since Congress passed the Veterans Judicial Review Act in 1988, VA regulations and benefits decisions have been subject to review in the U.S. Court of Appeals for Veterans Claims, or CAVC, the U.S. Court of Appeals for the Federal Circuit, and the U.S. Supreme Court. For most of that time, those courts applied the Chevron framework, named for a 1984 Supreme Court case that first articulated it, when deciding whether to afford deference to VA regulations interpreting ambiguous statutes. Chevron involved a two-step test requiring courts to ask first if a statute was ambiguous, and second, if the agency's rule interpreting that statute was reasonable. If the answer to both questions was yes, the court was to defer to the regulatory interpretation of the statute. In the 40 years since Chevron was decided, it became the most cited Supreme Court administrative law decision, and the CAVC alone has cited Chevron in 170 of its precedential decisions. Earlier this year, on June 28th, the Supreme Court issued its decision in Loper, reversing Chevron as inconsistent with the Administrative Procedure Act, or APA. In particular, the court held that the APA's charge that courts decide all relevant questions of law when reviewing an agency action conflicts with Chevron deference to agency interpretations. As a result, courts will no longer defer to an agency's interpretation of an ambiguous statute, and instead must decide the single best meaning of that statute. The Supreme Court did not, however, overrule individual cases applying Chevron, and those cases continue to be binding law. Although courts will no longer defer to agencies' regulatory interpretations of ambiguous statutes, courts may, under a separate doctrine called Skidmore, consider the agency's expertise as one of several factors when trying to decide what the best meaning of a statute is. The Supreme Court also emphasized that sometimes the best meaning of a statute may be that Congress intended to give an agency discretion in how to carry out the statute, such as explicit authority to define terms or to fill up the details of a statutory scheme. Loper does not direct Congress or agencies to change how they legislate or regulate. It only speaks to how courts should review statutes and the regulations interpreting those laws. While it is too soon to know exactly how Loper will influence courts and agencies, for VA, Loper will likely only directly impact how the CAVC and Federal Circuit review the statutes and VA regulations. Loper may, however, indirectly influence how VA regulates, both substantively, for example, VA might decide to adopt narrower or more cautious interpretations of statutes, and also from a practical or strategic standpoint. For example, VA may choose not to amend a regulation that has been upheld under Chevron. For its part, Congress may consider whether or how to use its legislative and oversight powers to shape rulemaking and judicial review post-Loper. Congress's authority over agencies is broad, and it could, for example, expand or contract specific statutory authorities, amend the APA, or use its power of the purse to influence agency action. Likewise, Congress could amend the APA or other judicial review statutes to guide the courts in interpreting statutes and regulations. Ultimately, any changes would require Congress to make policy decisions about the degree of control it wants to exert over agency activities and who should have the primary role in interpreting statutes. Thank you for the opportunity to testify today, and I look forward to your questions.
Thank you, Mr. Gaffney. Mr. Vicky Oni, you are now recognized.
Chairman Bost, Ranking Member Takano, and members of the committee, thank you so much for the opportunity to provide my views on the great opportunities our clients' victories in Loper Bright Enterprises and Raimondo v. Department of Commerce. They were combined cases, and I was counsel of record in Relentless. Provide the Congress to work its will, direct the executive branch, and among other things, improve veterans' lives. I've worked many years to overturn Chevron deference, as has my organization, the New Civil Liberties Alliance. Now that that task has been accomplished, the Congress can reassert itself as the founders believed it would and should to set the course for law and policies of the federal government. Since the momentous decision on June 28, 2024, I've been asked about the effect of the decision on administrative agencies and on lawmaking of the end of Chevron deference. Some commentators in the press have predicted the end of important environmental, social regulations merely because the agencies are no longer able to create ambiguities and then fill these ambiguities with whatever regulations they like, whether the law Congress passed authorized them or not. This is not so. Since the creation of the Interstate Commerce Act of 1877 to address the regulatory challenges of the intercontinental railroads, administrative regulatory power has been exercised by Congress and affirmed by courts, including the Supreme Court. In 1946, the Congress passed and President Harry Truman signed the Administrative Procedure Act, the APA. When Chevron deference came along in 1984, Congress had been creating administrative agencies that made regulations covering huge swaths of American life, including securities, energy, the environment, education, and veterans, for over 100 years. So Chevron did not even mention the APA that Congress had enacted to control agency regulation and its adjudication by the courts. Chief Justice Roberts' decision for the majority in Loper Bright relied on the language of the APA to strike down Chevron deference. While I and my organization believe the Constitution itself forbids Article III courts from deferring to an interpretation of the law by the Article II executive branch, it should be understood that the majority opinion relied on this Congress's written will that courts must decide all relevant questions of law. The case does not limit the ability of Congress to enact statutes to regulate, nor does it prevent constitutional delegation of authority on agencies. Chief Justice Roberts said for the majority, this is not to say that Congress cannot or does not confer discretionary authority on agencies. Congress may do so subject to constitutional limits, and it often has. The holding of the case is that, quote, courts must exercise their independent judgment in deciding whether an agency has acted within its statutory authority as the APA requires. Careful attention to the judgment of the executive branch may help inform that inquiry. And when a particular statute delegates authority to an agency consistent with constitutional limits, courts must respect the delegation while ensuring the agency acts within it. But courts need not, and under the APA may not, defer to an agency interpretation of the law simply because a statute is ambiguous. The subject of this hearing is how Congress can exercise its constitutional authority to ensure its legislative intent is being effectively communicated and implemented at the VA to serve veterans, their families, their survivors in the most effective way possible. Loper Bright does not change the power of Congress to control agencies, but it does mean that agencies will have to point to actual language and authority in statute to support regulations and regulatory actions. Now, my full comments are in the record, but I just want to emphasize a few points. Delegation has to be clear because ambiguities will no longer be filled with agency power. And it's interesting, when I was preparing my statement, the Supreme Court came out with its first opinion of this term, Borfa v. Mayorkas, and they compared the delegation to the Homeland Security Secretary, which was broad and uncabined by any language to remove visas, but they had lots of things to say about the Attorney General doing it, where you had to make findings of fact. So it's a nice case to look at about delegation and what the court's going to do about Congress. There's two problems with veterans. We represented in Buffington case a veteran who did not get certain benefits, and we wanted to use the veterans canon to show that it wasn't ambiguous. Congress wanted him to have it. And the Supreme Court denied that petition, but Justice Gorsuch prefaced what happened in Loper Bright and said, hey, look, we can't deny veterans benefits because of ambiguities that the agency has used. On the other end, there can be large projects created with deference that Congress may have not wanted to do. And those can be cabined, I think, by saying, here you have this authority and this delegation, but it can't go above a certain number or a certain amount of money. So there is a lot of work to do, but I don't believe that the case means that Congress will not be able to create regulatory agencies that take care of veterans. Thank you, and I welcome your questions.
We're now going to questions. I yield myself 5 minutes. Dr. Wallach, the Veterans Affairs Service Purchase Program, or VASP, that we both mentioned, was created under two authorities that have traditionally led to less than 100 loans being purchased a year by VA. And then over the next 2 years, VA estimates that there will be 60,000 loans will be eligible for VASP. Under these authorities, for a total of about $17 billion in loans purchased. Have you seen this amount of agency overreach elsewhere in government?
Unfortunately, I'd say that it's one of the typical patterns of 21st century American governance for the executive branch to blow up existing powers into things that were never contemplated by the Congress.
Wow. All right, well, Mr. Vicari, VA guidance excludes residential rehabilitation treatment programs from the Mission Act access standards for community care. VA states that they do not fall under hospital care, medical services, or extended care services as defined under Title 38. We do not believe that this interpretation aligns with Congressional's intent under the Mission Act. What actions, then, can Congress take or should take to require VA to apply the same access standards to the RRTP that exist for other forms of care?
I am not that familiar with that statute, but when I did take a look at it, and it strikes me that when an agency makes those determinations, somebody who is denied whatever benefit can always bring something to court. On the other side, when they give too much benefit, oftentimes no one can sue because who's hurt, right?
Right.
So I think in that case, Congress can certainly hold hearings and say, why'd you do that? But one of the things that has always struck me as odd is that congressional agencies rarely comment on regulations when they're proposed or definitions when they're proposed. We comment all the time. And then the agency has to respond in writing about why it's doing what it's doing. So you've got the power of the purse, but I also think that if you see a regulation coming along, notice and comment regulation, I don't know why more congressmen don't say something.
I agree. Mr. Square, to Squitieri, do you think that the Loper decision could affect the way a court views VA and DOJ's determination of the Second Amendment rights that came out during the Brady Bill? Specifically, veterans who cannot manage their VA funding and have a fiduciary, they have, without due process, have their rights removed through the NIC system.
Chairman, yeah, I think it would impact how the court considers it, in part because there might be, in the Second Amendment context, some sort of clearly a constitutional right at stake, and there are certain methods of interpretation called substantive canons that a judge could consider, and essentially interpreting the statute in a way to not upset a constitutional value. So I think because Loper Bright frees a court to consider the best reading of a statute, a judge might use an interpretive canon like that where an agency, perhaps an agency that's hostile to Second Amendment rights, would not want to use that canon.
Okay, this is going to be to all of you, and it's not a written down question, but it is a concern that I've had since I came to Congress on why we don't do certain things like states do. I never would say state of Illinois does things better than Congress because I was 20 years in the state legislature there. But let me tell you what they do and states do that is so right. When passing a law or passing an assignment to an agency, they have what's known as JCAR, and it's a Joint Committee on House and Senate Rules. And basically, after a law is passed, there is a bipartisan, bicameral committee that the chairman rotates every year from each one of the either Senate Republicans, Senate Democrats, Senate. And so it is truly a bipartisan, bicameral committee. The law that was passed cannot be implemented until the agency brings back their rules and how they're going to implement it, and they cannot implement it until they approved by that committee. So the intent of the legislature is clear. You can't, so in other words, if you had voted for, let's go to an example. When they legalized marijuana for recreational purposes in Illinois, several people on that committee did not vote for that, but they couldn't change what the actual law was that the people agreed to, but they had to make sure that the agency that had oversight did it correctly. When I brought this up, some of my colleagues, when I first got here, their answer was, do you realize how much work that would take? And my thought was, I think that's kind of what we're supposed to do. Would you think that that's something that Congress could move forward with? And would this cure our problem?
I mean, Chairman, it certainly bears some resemblance to the REINS Act that was debated so much over the past decade. And I do agree with Ranking Member Takano that if Congress were to take up that burden, it would need to invest in the capacity to deal with it intelligently. So I'm not sure whether it exists today. I've been an advocate of building a congressional regulation office that would help Congress grapple with these issues, but connecting it to something like the J-CAR would certainly be an option.
My time has expired, and I want to turn it over to Mr. Takano for his questions.
My first question is for Mr. Gaffney. Mr. Gaffney, how do you foresee the so-called Gardner or pro-veteran canon, which directs courts to interpret veterans' benefit statutes liberally for their beneficiaries to be treated by the courts post-Loper?
Thank you for that question. So Gardner is a canon that, as you said, directs courts to look at veteran statutes in a pro-veteran manner. And it's what's called, as my colleague mentioned, a substantive canon, meaning that it's not looking at the specific text of a statute, but at who the statute affects. Another example of a substantive canon might be the rule of lenity, where courts interpret criminal statutes in a way that favors defendants in criminal cases. So if there's an ambiguity, then they're not going to be imposing harsher penalties than what Congress may have intended. Now, some judges, including a couple of Supreme Court justices in the recent case Rudisill v. McDonough, expressed skepticism as to whether these substantive canons may still have a role, but they are still good law, and so this may be something that a court uses when trying to decide the best meaning of a statute in Loper.
Do you see them at all, do you see the pro-veteran canon potentially in jeopardy?
It's hard to say.
Hard to say.
As I said, several justices have expressed skepticism, but there hasn't been an official rule.
In Loper, the Supreme Court stated that while it was eliminating Chevron deference, this does not, in turn, foreclose agency discretion or courts' use of agency expertise. The court went on to say that when Congress delegates discretionary authority to an agency, it is now the court's role to define the limits of that discretionary authority. If Congress explicitly leaves discretion to an agency, is it not an overreach of power for the courts to insert themselves when Congress made its intent to delegate the determination of particulars to an agency?
That might depend on exactly what a court is addressing. If the delegation is clear, then the court should defer to that delegation as the clear intent of Congress. If there is some question about exactly what the contours of that deference are, that might be a place where a court could step in and try to decide where those fuzzy contours might be.
But could we objectively say that there is definitely a shift of power to the court to decide these things?
I'm not sure if it's a shift. Courts have always had some power to interpret statutes, and whether that's with deference to Chevron or not, depending on the context. But Congress could use its power to make legislation that is as clear as possible in order to shape how the courts come out on those things.
Well, how is it decided where Congress's grant of a discretion ends and the court's authority begins?
That's unfortunately a question that courts are going to take up and that Congress can respond to.
It's in the court, yeah.
Right.
So, Mr. Gaffney, does Congress have the same ability to hold courts accountable as it does agencies?
To some degree. The lower courts are creatures of statute. Congress can amend their jurisdiction. Congress can choose how much to appropriate to the courts. So Congress does have some degree of control over the courts and their operations and the standards of review under which they look at agency actions.
So, to all the witnesses, do you, and very briefly because I only have so much time, do you think legislative drafting and negotiations will be more or less difficult following Loper? starting with Mr. Squitieri, more or less?
I suppose I'm not sure. Congress will have to put the
So
policy on
you're
that.
not sure, Mr. Gaffney?
Congress would most likely have to consider the impact of its legislation and the lack of deference more than it would have.
Dr. Wallach?
Yeah, I suppose they're more consequential, and maybe that makes them more difficult. I think that's all right. This responsibility is supposed to be on Congress.
Mr. Vecchione?
At oral argument for Loper, Paul Clement said that Congress will now have to, they can't just hope that the presidential campaign will go the way they want and their friend will be there to make the laws. They're going to have to make the laws. So I think it's going to require more work.
Got it. Well, how will Loper affect bipartisanship and how lawmakers advance their political interests? I won't have time for each of them. I'm going to have to leave that to one of my colleagues to ask that. Again, for all our witnesses, would Congress benefit from an increase in legislative branch appropriations to support bringing on more staff in response to Loper? Mr. Squitieri?
More appropriations for congressional staff?
Yes.
Yes, I believe Congress would benefit from that.
Mr. Gaffney?
Assuming that Congress wants to take on more of this rulemaking and taking on some of the agency functions, that would probably be beneficial.
Dr. Wallach?
I think it matters how you expand appropriations. I think committee staff is the best place to invest in expertise in Congress.
So, I mean, if we're not deferring to executive expertise and the executive, the delegation having mostly the final say, Congress, in order to take that power back, is going to have to build up its cadre of expertise. Is that what you're saying, Dr. Wallach?
I'm in full agreement, yes.
Mr. Vecchione?
NCLA doesn't have a view on this, but I do. And I think that the executive, relying too much on the executive experts has caused Congress some problems.
So in response, if we don't want it to actually be decided by unelected judges, we're going to have to build that expertise here in Congress. My time has run out, and I yield back.
Thank you. Dr. Miller-Meeks, you're recognized for 5 minutes.
Thank you, Mr. Chair, and I thank all the witnesses for being here, and I also thank the chair for having this hearing. I will just say, given the last question, I'm more interested in a pay raise for the American people than I am for a pay raise for those who are within the federal government. And let me also say that I think it's appropriate to point out that, as the ranking member said, Congress's job is to make the laws. And therefore, this requires Congress to actually do its job, which I think all of you said. And I will give you an example of why this decision is important. So Congress passed a No Surprises Act bill. And it was to address an issue with patients getting surprise bills when they thought that they were in network and insurance companies decided they were out of network, or an expert being called in who was on a panel of doctors in a network, but then decided for reimbursement purposes was not on a panel. Congress was very explicit in how it wrote that legislation. However, HHS, under this administration, decided to interpret in a different way. The Loper decision forces us to craft laws in consideration of what happened in the Supreme Court in the Loper decision and to do a better job, as we did with the No Surprises Act, but an agency had interpreted it in a manner that they wished to and against the intent of Congress. So that's why I think this is important, and I know that's my opinion of that, but why I think the Loper decision is very important for Congress. Mr. Gaffney, post-Loper, how will the courts review potential challenges to VA regulatory actions not based on formal rulemaking, such as internal guidance or directives?
Thank you for that question. So post-Loper, instead of looking at whether VA's regulation is a reasonable interpretation of an ambiguous statute, courts are going to instead use their ordinary tools of construction to decide the meaning of that statute. And that could take several forms. One of the things they could do is look to see how the agency has interpreted and applied that statute over time. And that agency practice can be a factor that the courts will look to, but it won't be the exclusive factor that courts look to. They'll continue to exercise independent judgment.
And can Congress strike a balance between leveraging potential VA expertise, i.e. doing that prior to making legislation, while maintaining strict legislative oversight and accountability and putting forth what they intend legislation to be?
There certainly seem to be tools for Congress to do that, yes.
Thank you. Dr. Wallach, what recourse is there for this committee if the VA does not issue a formal rule, but instead issues guidance or directives that the committee disagrees with?
I think my view is that Congress just needs to pass more laws. It needs to be able to pass little laws that say, you've interpreted wrong and we need to correct you. And that needs to be a fairly efficient process. That is the ultimate tool. So if you have that threat of doing that, then maybe when you engage in informal communications as oversights, they're more likely to just listen to you in the first place.
Under Title 38 United States Code, Section 1714, Congress clearly stated that prosthetics for amputee veterans are intended to restore health and quality of life. However, in 2021, the VA issued a rule requiring that access to adaptive prosthetics must be directly tied to an active medical treatment or rehabilitation program, and they determined medical necessity, not the doctor. We believe this rule differs from Congress's clear intent to ensure lifelong access to prosthetics for veterans to restore health and quality of life. What recourse does Congress have in this circumstance?
Again, to me, it seems like, well, they got it wrong. Go in and tell them to get it right. I don't think that anything about, writing statutes is impossible. It's an inexact art, to be sure, but when you find out that it's gone a different way than what you wanted, you just have to go back in and fix it. And I know it's very difficult to move legislation through Congress these days, but we have to think about ways of making it easier when there is a situation where, especially on a bipartisan basis, members of Congress say, this is just not what we intended.
Or someone has to have enough means to pursue a lawsuit, which is tremendously unfortunate and works against most of our veterans. Mr. Vecchione, Congress stated that the VA must consider all of the evidence when deciding a veteran's claim for disability compensation. Do you think VA's regulation requiring an automatic denial of a veteran's claim if the veteran misses their disability compensation exam fulfills Congress's intent?
No, I don't. It's like the Buffington case where Congress didn't put in a statute of limitations. Our client put in for his benefits because he'd been put back on active duty, and then he was denied his benefits. Congress hadn't done that. It sounds like the same case.
Thank you so much. I yield back my time.
Thank you. Mr. McGarvey, you are recognized for 5 minutes.
Thank you, Mr. Chairman. I appreciate that. And went to law school, took a couple of semesters of constitutional law, and this is all really dense stuff. So I want to break this down a little bit and make it simpler. We're talking about these dense legal technical terms, but I think we can say what's really going on here, because this is more. This isn't a story of left versus right. This is not a story of urban versus rural. This is not a story of the Congress versus the VA. This is the classic tale of David versus Goliath, the big guy versus the little guy, the Rebel Alliance versus the Galactic Empire, if you will. Because what's happening here is that federal judges, a politically unaccountable class of elite law school educated individuals, are giving themselves more power over the people we represent and over the public servants and experts and agencies who have spent years on these topics, and importantly, whose heads are accountable to presidential elections every 4 years and congressional oversight all the time. I think everybody on this committee knows how often we drag the VA into Congress. So why is this important? Because rich lawyers, lobbying firms, claim sharks, think tanks who are funded by big business and the Koch brothers, like the two we have here in front of us today, and others with time and money and influence to bring lawsuits can hire their own experts who will try to get unelected judges to make laws that shockingly benefit them. So let's bring this down to earth with an example of how this could affect our vets at home. That's why we're here, to talk about how this impacts our veterans. The VA has made regulations, we've done some in this committee, to conduct the oversight of schools receiving GI Bill money. However, after this Supreme Court decision, a shady for-profit school could sue the VA, saying that their interpretation of how the VA conducts oversight is too expansive. An unelected judge would now have more latitude to say if the VA stepped out of line, even if the VA's implementation is exactly in line with what we intended to protect our veterans. So now this shady school has the money to hire rich DC lawyers and win the case, allowing them to make money while scamming our veterans at home. This is big versus little. This is rich corporations against the guy sitting in VFW 1181 in Louisville, Kentucky. And after this Supreme Court decision, Congress is going to have to be even more explicit, even more technical when writing laws, lest a rogue judge decide to add their own interpretation without accountability. But to do that, we have to have the dedicated resources in the legislative branch appropriations to ensure that we have the staff and the expertise we need. So I'm glad we have CRS testifying today, and I want to get it down to you guys. Mr. Gaffney, has the number of congressional staff increased or decreased since the Chevron decision in 1984?
We don't have exact numbers, but according to estimates, they have decreased since that time.
Okay. Has the number of committee staff gone up or down since Chevron?
It appears that those have also gone down.
How about the number of CRS staff? Has it grown since 1984?
I don't have that number in front of me, unfortunately.
Okay. You know what? I'm going to ask this, but the question is rhetorical. Has Congress's work generally become more complicated or less complicated in the last 40 years? Think about that. We are turning this power over to unelected judges and rich corporations and lawyers who have the time, energy to get what they want out of unelected federal officials. We're depriving our veterans of the expertise and service that they need to make sure they're getting what they have. I think we need more capacity in Congress to take care of our veterans and to make sure, and this is really important, that the decision-making stays closest to where it needs to be, not in the hands of think tanks and corporations and DC lawyers, but with the people. And the people have their power through their representatives, the representatives they elected to implement this legislation on their behalf, not to the unelected judges. Mr. Chairman, I yield back.
Thank you. Mr. Van Orten.
Thank you, Mr. Chairman. Mr. Wallach, I have to disagree with you. Congress does not need to pass more laws. We don't. Because if we keep passing more and more laws, eventually everything is going to be illegal. So I'd like you to rephrase that, because you were batting 1,000 until you said that. I'm the subcommittee chairman for economic opportunity, and I'm responsible for the two greatest programs the United States government has ever developed. The first one was the GI Bill, which allowed our veterans that never would have had a chance to go to college and educate themselves, and that built the nation that we live in. The second one is the VA loan program, and I've had multiple members of the VA come here, including Secretary McDonough and also Undersecretary Jacobs, and try to explain to me this VASP program. I don't know anybody here that thinks anybody who is not elected should have the ability to write a $16 or $17 billion check. And it's absolutely foolish. And when we say that we're going to defer to these agencies that have subject matter expertise, the VA does not have any subject matter expertise in executing these loans. So when the Veterans Affairs Administration wants to take on these loans, they're de facto purchasing this property. And that's wrong. And I asked him these questions. I said, hey, look, man, Undersecretary Jacobs, do you envision a world where the Veterans Affairs Administration would evict a veteran who has defaulted on their loans? And he said, absolutely. And then in another hearing, I asked Secretary McDonough, Secretary, do you envision a world where the Veterans Affairs Administration would evict a veteran that is delinquent on a loan? He said, absolutely not. And then we had the Undersecretary back in another hearing and asked him, I'm like, hey, look, man, you said you're going to evict veterans that are delinquent on loans, and then the Secretary said that he wouldn't, so who's running the frickin' VA? And that's the problem when we hand this power over to these unelected bureaucrats, because they just wind up pointing fingers at each other. And then the American taxpayers are on the line. So if the United States government, through the Veterans Affairs Administration, purchases loans that veterans are delinquent in, they knock off about 5 percentage points. First of all, the lending institution has to be made whole, right? So where's that money come from? I don't know. And then if they're never going to evict a veteran, because they're not, who is delinquent on their loans, that means that the United States government has private citizens living in government-controlled real estate without paying for anything. And they tried that once. It was in the Soviet Union. And that's where we're marching to. The bureaucracy, the state of bureaucracy, is what we're living in. We're not living in a democracy now. We're living in a bureaucracy. So having these people be able to write these massive checks without us being able to say whether or not they can is not, in my opinion, constitutional. It's very disturbing to see this. So when these people say we're not sure what Congress' intent is, I have told them directly to their face with my words, and I've also handed them documents, the written words, saying this is actually the intent. So it's very disturbing to see this stuff happen. So you're a constitutional attorney, sir.
Professor, yes.
Professor, sorry. So do you see that just this has gotten cattywampus here, where we have these folks, I mean, that's a technical term of art, where we have these folks that are appointed and they're de facto legislating through regulation. Is that how you saw, or do you think that our founding fathers designed our Constitution and our government?
No, and I think you put your finger directly on the issue, and when you compare democracy with bureaucracy, and that there's been some critiques that the court is somehow claiming power by interpreting the law, and that's problematic because they're unelected. But of course, the people and agencies are unelected as well. So I think drawing the line that you have is a good one to draw, and Congress should be writing laws, courts should be interpreting them, and agencies should have, frankly, as little discretion as needed to get the job done.
Yes, we write the laws. The judicial branch says whether or not they're in compliance with the Constitution, and then those are handed as a manual to the executive branch to execute our will, right?
Yes.
Okay, why is that so hard? It's fascinating to me. I want to thank you guys for coming. I also, on the last note, I had a reporter ask me, how is this going to affect our staff? Because I know we're concerned about staffing. And they specifically said, how is this going to affect your staff? And I said, it's not going to affect my staff at all, because we already do all this work. We do very prescriptive legislation, as I think that we've been told to by the Constitution. So with that, I want to wish you all a very Merry Christmas. God bless you and your families, and I yield back.
Thank you. Representative Bazinski, you're recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you, Ranking Member, and thank you to the panelists for being here. I appreciate this opportunity to discuss the implications of the Loper Bright decision that was recently made, and my concerns are really around what this is going to mean for millions of veterans in this country. Again, I want to emphasize something that's been said, but this is really a decision that overturned decades of precedent. The court has put more decision-making power into the hands of judges to implement and improve programs for our nation's veterans. Many of the experts at the VA are veterans themselves and have dedicated their lives to serving our vets. And I think that's an important point to emphasize. The VA relies on the expertise of doctors, caregivers, and subject matter experts to make crucial decisions that impact our veterans' daily lives. Over 70% of all U.S. practicing physicians are trained at a VA facility at some point in their career. The VA is a training ground for our doctors, nurses, and other clinicians, and our nation's medical system at large. The VA has been a pioneer in medical research that has led to significant breakthroughs in the medical field, including in surgical procedures, prosthetics, and PTSD treatment. That's what these experts have been working on in the VA. Over 9.1 million veterans are enrolled in VA healthcare and benefit from and rely on this expertise and research. But my biggest concern is that now we risk leaving critical decisions to unelected judges that are not close to these veterans directly in their daily lives and the expertise that they have built in this work. These judges now are going to have the ability to make decisions on deep and complex needs that our veterans have every day. So this is extremely concerning for all who have served, and especially for so many of our women veterans, rural veterans, and others who may require specialized assistance navigating the VA continuum of care. So my question is for Mr. Gaffney. How would you describe the rulemaking authority Congress has granted VA in comparison to other agencies? Is it more broad or less broad?
It's difficult to do an apples-to-apples comparison, but there do seem to be some broader authorities in at least some places within the VA system.
And Mr. Gaffney, how will the Loper-Bright decision change how courts interpret laws where Congress has delegated interpretive authority to an agency?
Where there's express delegation of interpretive authority, this probably won't change how courts interpret those laws. In fact, under the Administrative Procedure Act and the statutes governing the CAVC's review of the VA decisions and regulations already provide for what's called arbitrary and capricious review of those sorts of discretionary decisions. So courts are going to be looking to whether VA's actions in carrying out and filling out those schemes are reasonable. And that was true both before and after Loper.
Okay. Mr. Gaffney, one of the more troubling sections of your testimony was about the lingering uncertainty as to how judicial interpretations of statutes will affect an agency's ability to reinterpret statutes via regulation. In other words, under Loper, a judge may lock in its interpretation of the law and preclude or limit an agency from later interpreting that statute. How do you see this playing out in the context of veterans law and how VA engages in the rulemaking process?
I think what we'll probably see is something akin to when courts were deciding cases under the first part of the Chevron test, where they would find that a statute was not ambiguous. In that case, those statutory interpretations were binding on the agency, and the only mechanism for changing the meaning of the statute at that point would be for Congress to come back and amend the underlying statute. So that would be the remedy there.
Okay, I yield back. Thank you, Mr. Chairman.
Thank you. Mr. Sell, you're recognized for 5 minutes.
Thank you, Mr. Chairman. A couple of comments before I get started. My Texas colleague, Dr. Michael Burgess, made a comment not long ago about a specific HHS bill that he said the rules written by HHS were, and these were his words, diametrically opposed to the will of Congress. That's what we're fighting here. Secondly, during our earlier discussion about our 2A rights, I asked, for this purposes, unnamed VA official, based on his testimony, what was the supreme law of the land? And he screwed up his face like he didn't understand the question. That's what we're dealing with here. This is truly, and I agree with some of my colleagues across the aisle that this is the elites versus the law, but I take a 360-degree opposite view of what they're looking at. Because whether it's a congressional law or whether it's a rule by any agency, to the veteran on the street or the citizen on the street, it carries sanctions. It carries benefits. So this is why we've got to stick to the separation of powers. And frankly, I hear a lot of DC talk here, and I understand we got to get to the bottom of this. But we've also run to the most extreme case here, litigation. So somebody walk me through. Congress makes a law. VA, for instance, then issues rules. Now, we have the CRA immediately available to us. So how do we get, and who has standing for litigation? Somebody just walk me through the simplest way, because we've got congressional law, we've got VA rule, we've got a CRA available to us. We get to litigation. Who has standing?
I think I better take this one since it's a large part of my life, figuring that out. When somebody's denied a benefit, like the prosthetic case we heard about, they have standing because they're immediately injured. It's why the benefits case get up to the Supreme Court quite often. And the language about that I was asked by the chairman about the interpretation of a language, once you're denied something, those people have standing because they're immediately injured. Mr. Gaffney's written testimony explained where the veterans' claims go and how they're done, and it's almost always they were denied something. And Chevron, when there was an ambiguity, the government always won. The part of this was, and when we see, and I want to address some of the questions about what's happened is that immigrants and veterans on the remands are more likely to win than they were before, because once an ambiguous statute was interpreted in a regulation by the agencies, they won.
Okay, stop right there.
Yeah.
You've just given us the most important point of this hearing. Thank you for that. Now continue.
And then, so standing is a larger problem. When the executive takes over the budgetary powers, as Congressman Van Orden was saying, that's why in my testimony I said you want to give deference to the VA because you can't know what the situation is off an island off Louisiana or up in Alaska or out in Maine or what's happening in a big city. They do need discretion, but you may want to change budgetary discretion. But that discretion is turned into a giant thing like DACA or student loan, just forgive $500 billion.
Thank you.
Very hard to get standing in those cases because who's hurt? Only Congress can usually sue.
Thank you very much, and you got to the point I was looking for. If we want our veterans to have better care, be taken care of, and win their cases, this is what we have today under Loper. Thank you, and I yield back.
Representative Brownlee, you recognize for 5 minutes.
Thank you, Mr. Chairman. Mr. Gaffney, I think Ms. Budzinski might have asked this question, but just to make sure, I'm going to ask my question, and that is, when the administration changes, an incoming administration might have a different interpretation of statute than the previous and may engage in rulemaking to reflect that interpretation. How do these kind of flip-flops play out in federal courts?
So that's going to depend on whether the court has interpreted the statute that the regulation is also interpreting. If the court has interpreted that statute either under Chevron Step 1, under the old system, or under Loper now, then that's going to bind the agency. If the court has not interpreted the statute, or if the court deferred to a previous agency interpretation of the statute in a regulation, then the agency will be able to still change its regulation interpreting that statute.
Okay. Another question, is it possible to draft legislation that would give the executive branch the authority to promulgate rules when a statute is vague, and what would that authority look like constitutionally?
So it does seem to be possible. There may be some limitations on that, but an example might be the authority that Congress has given VA to add presumptions for different kinds of benefits related to Agent Orange exposure. It set boundaries on that, but it gave the agency the authority to create additional presumptions and fill out the statutory scheme without having to come back to Congress for legislative authority. In the Loper decision, the court talked about a couple of different things that they could say, such as giving the secretary the authority to create reasonable or appropriate rules, or to define a specific term or to fill out the terms of that statutory authority.
Thank you. Again, another question to you, Mr. Gaffney. So the United States Code grants the VA the authority to care for veterans. It specifically states the secretary shall furnish hospital care and medical services which the secretary determines to be needed. Do we now have to be concerned what hospital care and medical services mean? For example, are medical services elective treatments? Does Congress now need to specify every medical condition the VA could potentially treat in statute? To what extent can the VA's ability to furnish medical care be challenged?
Those are excellent questions, and I think that probably is something Congress needs to consider both in that case and other cases in terms of who should have the authority to decide what a term means if it's not explicitly defined in the statute, whether that's a court or an agency or whether that's Congress coming back and defining the term more specifically.
I mean, that can blow up a lot. I mean, the whole notion of the VA and certainly mission of the VA is to provide high-quality health care to our veterans. So thank you for that. Mr. Squitieri, in your testimony, you suggest using Loper Bright as an inspiration to go even further with regard to court deference to agencies by noting Kaiser deference. You say that we on the committee might find that it is often the VA's interpretation of the VA's own regulations rather than the VA's interpretations of statutes that are most objectionable. Could you please elaborate on your reasoning behind this and give an example of when you found this to be the case for the VA?
Sure. So there's, just like when Congress enacts laws, the VA, of course, promulgates regulations, and those regulations themselves can sometimes be ambiguous. And the court, going back to, I think, initially the 1940s, said that the court will defer to an agency's interpretation of its own regulations. And that's particularly problematic, I think even more problematic than Chevron, because you have the power of both drafting and interpreting in the same hands. As to a particular instance in the VA context, I would refer you to perhaps Kaiser itself. I forget the specifics of that regulation, but I believe it was something about what sort of documents had to be shown by the veteran in that case, and the VA was afforded deference. Whereas if this committee enacted a law that says no more Kaiser deference to the VA, a court would be able to say, look, the veteran and the VA are now equals as far as interpretations, as compared to saying we're going to side with the VA.
Thank you. And last question, I have just a little bit of time, but this is really to anybody on the panel. Which VA health regulations do you think are most susceptible to being turned over in the wake of Loper Bright? Anybody have an answer to that? No? I yield back.
Thank you. Representative Rosendale, you're recognized for 5 minutes.
Thank you very much, Chairman Bost. The Constitution is clear that the legislative branch, not the executive branch, writes the law. For too long, Congress has abdicated its responsibility by allowing unelected bureaucrats to promulgate rules that go further than the underlying statute passed by Congress provides. Many in Congress, unfortunately, are okay with this dynamic because it allows us to escape making any difficult decisions. Since 1984 case of Chevron USA, Inc. versus Natural Resource Defense Council, Inc., federal courts deferred to an agency's interpretation of an ambiguous law. This flawed ruling set our country back significantly. In 1984, our total public debt was 40% of the gross domestic product, and now it is 121%. The country has suffered immensely from members of Congress ceding our authority to the executive branch. The Biden administration has been particularly egregious in abusing the court case by claiming that a 2003 law intended to help service members provided for the pretext of their unconstitutional student loan redistribution scheme. The VA has abused its authority to provide abortions despite Section 106 of the Veterans Health Care Act of 1992 specifically prohibiting abortions. The Supreme Court, through Loper Bright Enterprises v. Raimondo, rectified the flawed decision from 1984 by telling federal courts not to replace their judgment with an agency's judgment. The American people sent us here to do our job, and now it's time for us to pass clear legislation that leaves little interpretation to be abused by bureaucrats. If you allow others, whether they're unelected judges, as the ranker said, or unelected bureaucrats, as folks on this side of the aisle have been recommending, to make decisions about the implementation of policies, you've abdicated your responsibilities. It doesn't matter which group of these unelected bureaucrats we defer to. It is wrong. Write the laws tight and don't grant rulemaking authority. Or, as Dr. Wallich says, amend it and refine it. And that way we can improve it and make sure it is being implemented the way that we want it. We cannot be lazy legislators and think that laws will be implemented the way that we think or that we hope they will be. And finally, put more people on committees that they are qualified for instead of the committee that they can raise the most money in, because that takes place every single day in this organization as well. Professor Squitieri, please elaborate on why the Loper Bright Enterprises Raimondo decision is good for Congress.
Congressman, I think it's good for Congress because it tells Congress that they can't just kick the can really anymore. There was an incentive, I think, in the past to just write vague laws and hope that a congressman's friend and the agency will interpret it as the congressman likes, and particularly with congressional staff bouncing back and forth between agencies. Now the political calculus has changed where a legislator says, well, this law is not going to be interpreted by my friends half the time or non-friends the other half the time. It's going to be interpreted by a politically neutral judge. So I think that gives the incentive for Congress to, yeah, it might take some hard work to hammer out a solution in the text of legislation, but to go ahead and do that because a judge is, going to give that interpretation its best reading and not really let politics come into play.
Thank you. In your testimony, you mentioned Congress should recognize the limits of the case and go further. What do you mean by that?
Oh, in particular, Kaiser deference. I think it's debatable whether that was affected by Loper Bright. I take the position that it probably was not. But this committee could solve that today and say, no Kaiser deference across the administrative state would be fantastic, but the VA in particular.
Okay. I contend that we should write laws much, much tighter, refine them as we get information, and yet we have members of the Veterans Administration that came before us just yesterday requesting additional latitudes. How do you feel about that?
With agencies requesting additional latitudes?
And flexibility so that they can do their job easier, better.
Well, I would say, and I think this is an important point, that there is, it's philosophically debated, but there's a distinction between law and policy. And Loper Bright is not supposed to limit agency policy discretion really at all. It only limits agencies' authority to interpret the law, but agencies still have authority to make policy discretion. So to the extent that agencies are asking for more policy discretion, I'd be skeptical that they really need it. And if it were to be granted by Congress, I think Congress should include factors, say, okay, yes, we'll give you this discretion, but you must consider X. You can never do Y, things like that.
Thank you so much. Thank you very much, Mr. Chair. I yield back.
Representative Ramirez.
Thank you, Chairman. Appreciate it. So in this hearing, as you've heard from my colleagues, we're investigating how the recent Supreme Court ruling will impact agencies' ability to interpret congressional law. And of course, we're in the Veteran Affairs Committee. We're specifically talking about the impact it's going to have on veteran affairs. And many of my colleagues across the aisle have talked about protecting our veterans. I agree with you. We should be in the committees that we're going to be actually doing the work and not there for our own political gain. So I take the work of this committee very seriously. I worked in the nonprofit sector and had to work often with a lot of these organizations, a lot of these departments. And I often ask myself, what is the process in which we put together some of the rulemaking? But also, I've asked myself, why does Congress or the state legislature or city council pass certain legislation without getting input from those that are most impacted? So this is an important hearing today. But I also find it deeply unserious that the same colleagues can be in support of rulings that will create greater complexity and even more uncertainty for our veterans. Because what we want to do is to make sure that they get as many resources as easy as possible, and certainly that it is consistent with the intent of the congressional law. These rulings, to me, set some dangerous precedent that would limit our ability to collaborate and problem solve with agencies, that will get in the way of flexibility. I mean, folks, not every single veteran has the same experience. And instead of improving their future and having the flexibility, and let me say, I hope this never happens again, but for instance, we have another pandemic strike in our communities. So I am concerned with these rulings. And that being said, I want to talk a little bit more about the VASP program, the Veteran Assistance Servicing Purchase Program. The program is meant to help veterans experiencing severe financial hardship, keep them from losing their home, a priority for all of us here. And it's a critical program that helps more than 40,000 veterans stay in their homes. And it was made possible by discretionary powers that the VA was given. So, Dr. Wallach, I want to ask you this question. In your remarks, you stated that the VA's actions on the VASP exceeded the agency's authorities. Is that correct? And you said this, and so my question to you is, does Congress have the authority to overrule VA and pass their own loan modification program? Do we have that authority?
Absolutely.
Yeah. So if so, doesn't that show that Congress ultimately holds the final say on how agencies act?
Unfortunately, inferring anything from congressional inaction about Congress's intent is pretty fraught because, as we know, it is difficult to move legislation. So I would certainly not want to agree to the idea that just because Congress doesn't get its act together
Well, give me a
to pass
second,
law,
Dr. Wallach.
that it agrees
Ultimately,
with what's happening.
thank you, Dr. Wallach. Ultimately, Congress holds the final say on how agencies act. We are the oversight committee of the Veteran Affairs, and we are the ones that are creating laws. So I guess my question often is there anything stopping this body other than political will to make these changes? And rhetorically, could Chair Bost, you don't have to answer this, but pass a bill that would change VASP? He could. We could, right? So the question is, why haven't we? And under President Trump, VA used authorities to prevent veterans from losing their homes under the VA Home Loan Program. These actions continued with the creation of VASP. Not one member of this body, Republican or Democratic, filed legislation to block or end this program. Not one. Isn't it a lack of action by Congress, an endorsement of VA having these authorities?
I wouldn't say so. I think there's political gridlock is a phenomenon we all are intimately familiar with, and the executive branch uses its presumption of gridlock to insulate itself from political accountability too often. So I think that's the reality, and I don't think that you should be able to infer that Congress is endorsing what's going on because of that.
Thank you, Dr. Wallach. So look, there's certainly political gridlock here, but if we are saying that this is a body whose intention is to improving the lives, particularly in this moment, of veterans, that the legislation that we're creating, and if we're talking about tightening the legislation, then if we're waiting on political gridlock to actually develop, determine, and create those specific rules, then we are saying that veterans in many cases are waiting and waiting and waiting for programs. Look, in closing, I just have a couple of seconds. What needs to be absolutely clear is that every resource and tool an agency has to help our communities should be at their disposal. Despite the challenges and barriers ahead of us, I am committed, like I think my Democratic colleagues are, to continue to deliver for our veterans, to have the access to the benefits they earn, instead of creating more complexity and more challenges to them. And with that, Chairman Bost, I yield back.
Thank you. Before I recognize there's first one, I do want to say something. There actually was a bill, and Van Orton actually has that bill. So you know, just, yeah, today? No, probably not today. Representative Radewagen.
Thank you, Mr. Chairman. Mr. Vecchione, in your testimony, you discuss how vagueness in the law could allow for variations in interpretation from one administration to the next. Can you discuss the effect such seesawing would have on veterans and their relationship with VA?
It's not just their relationship with VA, it's the relationship with the Congress. You pass a law. I'm a veteran. I'm a veterans organization. How am I to know what that law consists of if it can have a 180-degree spin from one administration to the next? One of the reasons Chevron, and I've been doing this a long time, courts, even the lower courts where I lost, the district court judges, and they said, look, I'm bound by Chevron. But they thought it was a scandal to the judicial mind that a written law could mean a 180-degree difference. And in fact, even at the Supreme Court hearing, Clarence Thomas wrote the Brand X decision, which, you know, this is the Christmas season. It's dead as a doornail like Marley, I think. But the fact is, you could switch back and forth just because the agency changed its mind with no one coming to Congress. So how is a veteran able to say what the law means to him? How is he able to even come to this committee and say, we need this change? He can't. So it breaks the tie between the constituent and Congress, and it also, I agree with the fact that now the agencies, including the Veteran Administration, are not going to be changing things as much, because if they've got a rule that's been judicially sanctioned already, even under Chevron, they're probably good to go. That interpretation can last. But I think that for veterans and Congress, you don't want them not to know what your law means, because the administration can change it to mean exactly the opposite of what the other administration did.
Mr. Gaffney, How can Congress influence future VA regulatory policies and guidance to ensure that the laws are being carried out as Congress intended?
There are a number of ways that Congress could do so. The first is through the regular legislative process by passing legislation that more specifically directs VA in what Congress wants VA to do. Congress can use its appropriations power to shape agency action. And Congress can come back after a VA regulation or after a court decision interpreting a statute and amend the statute to make clear if the agency or the courts in Congress's mind got the interpretation wrong.
So, Mr. Gaffney, after Loper Bright, do you think the courts would be more likely to consider committee bill reports and other legislative history when deciding whether a VA regulation violates congressional intent?
That's difficult to say and may depend on the judge looking at the case. I will say that many judges in the last decade have shied away from using legislative history. And I don't necessarily think that Loper will change that. Legislative history, when it's been used, seems to be used as a way of bolstering a textual analysis rather than taking the place of a textual analysis.
Thank you, Mr. Chairman. I yield back the balance of my time.
Thank you. Representative Shifless-McCormick, you are recognized for 5 minutes.
Thank you, Mr. Chairman. We are here today to discuss the implications of the Loper-Bright decision, another erroneous Supreme Court ruling that ignores 40 years of precedent and gives more power to unelected judges over nonpartisan expert agency staff. While my friends across the aisle claim that this decision will result in Congress asserting its legislative authority, this could not be further from the truth. Rather than the Loper-Bright ruling, the Loper-Bright ruling undermines Congress's Article I authority and allows judges with no policy expertise to be the final arbiter of Congress's intent. Ultimately, the result of the Loper-Bright decision will be a more politicized judiciary comprised of unelected unaccountable judges that can legislate from the bench on topics they have little to no knowledge about, as well as windfall for corporate lawyers and lobbyists who will certainly exploit this ruling for their own financial gain. While the judiciary branch will be emboldened, Congress will be significantly constrained in how it drafts bills. To succeed in the post-Loper world, Congress will need to hire more expert staff and rely even more heavily on CRS and the Office of Legislative Counsel. CRS and Legislative Counsel are already limited in their budget, and their staff are overworked and underpaid. Mr. Gaffney, what do you see as CRS's role in helping congressional staff shape and draft legislation post-Loper Bright?
CRS and the Office of Legislative Counsel are ready to assist with whatever Congress needs. And we are here to work with you individually, with the committee, with individual members and their staff to answer the questions and help your process as best we can. As always, CRS can provide objective and nonpartisan advice on the interpretation of laws, on policy questions, and we're ready and able to do that.
Mr. Gaffney, does CRS currently have the capacity needed to help staff with the technical research required to ensure that their intentions are clear after court scrutiny following Loper?
I would defer CRS personnel questions to my upper division management. It's a little bit above my pay grade, but we are here and we're ready to help you.
Again, for Mr. Gaffney, as we look forward to hopefully completing the FY 2025 appropriations process, would you agree that Congress should include more funding for CRS to help your organization operate successfully in a post-Loper world?
I unfortunately can't take a position on that question.
Well, what would be your opinion?
Unfortunately, it's not for me to say in my current role here. I can opine on legal questions for you, but as far as CRS staffing issues go, I would defer to my senior management.
Well, my last question for you is, how will the Loper-Bright decision change how the Office of Legislative Counsel works with staff to draft legislation?
I would defer that to the Office of Legislative Counsel, but I would say again that CRS and the Office of Legislative Counsel are always able to work together and with you on these questions.
Thank you. I yield back.
Representative Luttrell, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Wallach and Mr. Gaffney, Ms. Brownlee asked you a question. Ms. Brownlee, I may need you to ask that question again if you don't mind. She asked you about the doctors inside the VA and the latitudes that they have, which I thought was an amazing question. But Mr. Wallach, you had, impressively so, I was watching your mind work. Do you remember the question that Ms. Brownlee asked? I know you remember every single question that was asked in this room today, but can you unpack what was rolling through your mind? I'd be curious to see how we're going to Because to her point, this is a very delicate space we operate in. The doctors and clinicians that work inside the VA need latitudes. As a former researcher myself, I understand the necessity of that. So there's going to be a delicate balance that we need to have, but I'd like to hear your thoughts on it, if you don't mind.
Sure. My view is it's important to recognize that expertise is always on a particular topic. Just because you're the expert doesn't give you the full view of everything that's happening. So yes, we absolutely need to build in places for experts to use their expert judgment where it's appropriate, where it's actually applicable. But, you know, as we've talked about, oftentimes you have people who are experts in the administration of healthcare to veterans deciding whether to start a big new loan program. That doesn't seem like something that's actually within the scope of their expertise. So we can't just be intimidated by the fact that we say, oh, there's experts in the executive branch, we ought to let them make policy. No, they ought to have their place to use their expertise, but not go beyond that.
Yeah, one of the biggest concerns that I have is that, and Mr. Vicone? Yeah. Okay, yeah. So one of the biggest concerns that I have is that, you know, we do pass legislations, but again, administrations or leadership that's put in place will flip those rules and regulations to their benefit, which is very detrimental, or it could live and breathe in a good spot. It seems like at times the gate has been open and the horses are out, and we have no control over it inside this legislative body, which is our primary role and responsibility. But I'm curious, and Mr. Squitieri, you can help me, if you wouldn't mind, in your thoughts with what we're talking about today, if you would put that in crayon for me as we move forward into the next administration and administration after that, administration after that, because the VA is very special to not only to the veterans on this panel, but to, you know, arguably, you know, our veterans are the most cherished asset we have.
Yes, so to limit the horse out the barn scenario, I think Congress just needs to be as clear as possible in legislative text, hold plenty of congressional oversight hearings of VA officials and ask them why they're interpreting things certain ways. And I would say that members on both sides of the aisle on Congress should keep up that motivation regardless of what political party is in the White House, because I think Congress will oftentimes think, okay, this VA, I really like what they're doing, and that's great, but I think Congress needs to always keep in mind, well, what about down the road? What could we be putting in congressional text now when, for example, there's a majority in Congress? What could we be putting in legislative text now to help alleviate that kind of horse out the barn scenario that, you know, future administrations decades down the road?
The challenge that we have is communication down inside the organization is different than communication out and up outside the organization to us, and we have to bridge that gap, because the things that happen inside the VA are presented to us very differently, which is something that we're going to need to work on. But I thank you for the answering that question, sir, and thank you for your time, Mr. Chairman. I yield back.
Thank you. We want to thank the panel. This has been a very, very good discussion. Representative Takano, do you have any closing remarks?
I too agree it's been an enlightening panel, and it seems that, you know, both sides of the aisle are concerned about unelected decision makers contravening the will of Congress. And I do think that we need to take into account the dangers of unelected bureaucracies, but also an unelected judiciary that is effectively arrogating power to itself. And I don't think we can deceive ourselves into thinking that we can trust the judiciary to decide itself how much power can Congress delegate and how much it can't, and when Congress is intentionally being flexible or not by going back to the legislative record or legislative commentary. But look, we're facing a new court doctrine that's evolving. I think what I've heard from the testimony from different perspectives before us is that it would behoove Congress to arm itself with its own expertise to be prepared to do more legislating, which means we're going to have to become better legislators, more fully equipped with staff, and the kind of expertise that the bureaucracies and the departments and agencies have armed themselves with, we're going to have to arm ourselves with. So, and not be more self-reliant and more confident and potentially more particular in how we legislate. I yield back.
And I agree with you. It is something that, as we move forward on this, thank you to the panel. I do want to say a really special, this is the last hearing, and I hope that all of our members are listening out there. I want to say a special thank you to the ranking member for the last 2 years. We don't always agree. Matter of fact, quite often we disagree, but we don't take it personal. And I want to thank him for his work. I also want to say thank you to every member that's here. Those that are leaving, thank you for your service. Those that are coming back, look forward to the next 2 years to be working there. And let me say a very special thank you to both the Democrat and Republican staff for amazing jobs. Amazing jobs. And we're going to continue to work on these things. And I'm thankful, as I said, for the witnesses today, and it is essential that we get things done when we come back. And with that, I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks, and including all extenuous material. Hearing no objection, so ordered. This hearing is now adjourned.